The select committees will please come to order. Mr. Attorney General, welcome, sir.
Thank you.
Will you please rise and take the oath? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Mr. Niels?
Good morning, Mr. Attorney General.
Good morning, Counsel.
I understand you have a statement.
Attorney General, do you have an opening statement?
Thank you, Mr. Chairman. I do, and I believe copies have been distributed. With the permission of the Chair, I would like to have the entire statement submitted as a part of the record, but if, with your permission, I will only read parts of it in the interest of time. Chairman Inouye, Chairman Hamilton, members and counsel of these committees, I welcome this opportunity to come before these committees and assist in your review of this administration's Iranian policy initiatives, as well as other activities that were aimed at providing funding for the freedom fighters in Nicaragua. A number of witnesses have preceded me and provided an accounting of the policy decisions that were made and that were not made, and have described efforts undertaken for the ostensible purpose of furthering those policies. Before continuing that description, let me discuss briefly my role. As the Attorney General of the United States, it is, of course, one of my responsibilities to serve as the nation's chief law enforcement officer. In that capacity, I am privileged to assist the President in making sure that the laws of the United States are faithfully executed. In addition, as prescribed in the Judiciary Act of 1789, which created the Office of Attorney General, I am assigned the responsibility of providing legal advice and opinions to the President on such matters and at such times as he directs. Further, the Attorney General is, and has been since 1791, a member of the President's Cabinet, and thus has the distinctly separate role as one of the general advisors to the President and the executive branch. My exposure to the Iran-Contra matter was not confined to any one of those areas of responsibility, but from time to time has touched them all. I believe that one can better understand and appreciate my limited role in the events of the period by understanding in which of the several capacities I was approached for advice and assistance. Some 8 months ago, the President asked me as his principal legal advisor to develop a factual overview of the events relating to the Iranian initiative. During that hectic weekend in November 1986, we were able to piece together a basic outline of what is now known as the Iran-Contra story, which has been essentially validated during the extensive investigations which have occurred since. I mention this because after many months of televised hearings and intensive press coverage, some might understandably have difficulty recalling that, as we embarked on our fact-finding inquiry on the 21st of November 1986, few people inside or outside the government understood the true nature and scope of the Iran matter, let alone knew of the many details of the related activities and events. I certainly had no such detailed knowledge. My first exposure to the Iran initiative was in reality rather brief. I recall on the 7th of January 1986 being asked to attend a meeting with the President in the Oval Office along with other members of the Cabinet and certain members of the White House staff. Parenthetically, let me state that my calendar shows, and I've been told by others, that on the previous day, the 6th of January, the Deputy Attorney General, Lowell Jensen, and I met with Lieutenant Colonel Oliver North, who gave us a short briefing on an Iranian initiative. I do not specifically remember that meeting, but I am satisfied that it took place. At the meeting on the 7th of January in the President's office, Admiral Poindexter and Director Casey raised the proposed Iran initiative. As described, the initiative involved overtures to more moderate elements in Iran and the cultivation of a relationship that could in the future be to the geopolitical advantage of the United States. The proposal was also described as possibly helping to end the long Iran-Iraq war. The initiative was also seen as a means for decreasing Iranian sponsorship of terrorism, forestalling Soviet designs on the area, and gaining Iranian assistance for the release of the Americans then being held hostage in the Middle East. We discussed the Israeli suggestions concerning the initiative, especially concerning a transfer of arms from the United States and assistance in the release of hostages from Iran as a means of establishing with each side the good faith of the other. I was present at that meeting both as the President's legal advisor and as a member of the Cabinet and of the NSC. One legal issue that was raised concerned the appropriate statutory authority for an arms transfer as part of the strategic initiative. Based on my familiarity with a 1981 opinion by then Attorney General William French Smith, I concurred with the view of Director Casey that it would be legal for the President to authorize arms transfers pursuant to the National Security Act. Admiral Poindexter and Director Casey favored the initiative. Secretary Shultz and Secretary Weinberger opposed it. My own counsel was that while a very close question, the benefits seemed to slightly outweigh the risks, especially since I had the impression at that time that a time frame of 30 to 60 days was contemplated and that the risks were therefore short-term. It's my recollection that the meeting included a brief discussion that a presidential finding would be necessary because of the proposed involvement of the Central Intelligence Agency. I believe there was also a discussion of the necessity of notifying Congress and the legality of delaying that notification because of the extreme hazard to the hostages and others. I do not recall anyone at the meeting arguing in favor of immediate notification. With regard to the legality of the delay, I do recall stating that I believed a short delay was appropriate, but wanted to examine the statute before I agreed that such a postponement would be permissible. At the conclusion of the meeting, the President decided that the project was worth pursuing and directed Admiral Poindexter and Director Casey to proceed. I should add parenthetically that it was not my understanding at the meeting that anyone was discussing arms for hostages transactions, or that the President understood the proposal in those terms. Quite the contrary, no deals were to be made with any of the groups who had taken or were holding American hostages. The President was very firm on this point. A limited number of defensive weapons were to be sold to certain Iranians to demonstrate the United States' good faith. They, in turn, as a display of their good faith, were to negotiate separately with forces in Lebanon for the return of the American hostages. No direct dealings with the hostage takers nor the payment of any type of ransom was ever contemplated. Following the meeting on the 7th of January and over the next 10 days, I attended one or possibly two follow-up meetings which included Director Casey, Admiral Poindexter, CIA General Counsel Sporkin, and myself. The one meeting that I most clearly recall took place on the 16th of January, 1986. I believe that Secretary Weinberger also attended at least part of that meeting. We discussed Section 501 of the National Security Act, the law involving notification to Congress of certain covert activities. General Counsel Sporkin explained his analysis of the statute. After reviewing the statute, I concurred with the Central Intelligence Agency's advice that notification to Congress could, in the circumstances, be postponed due to the imminent danger facing the hostages. In this regard, I should emphasize that the expectation at the meetings that I attended in January was that the administration would notify Congress as soon as possible after the hostages were on board an airplane out of the Middle East and under the control of the United States. There was no desire or plan, to my knowledge, to keep this matter from the Congress. There was simply a recognition that this was a highly sensitive activity and that human lives were at stake, the lives of the American hostages and the lives of the more pragmatic Iranian elements who were willing to attempt a relationship with the United States. We were all acutely aware that if word of the initiative got out, however innocently or inadvertently, it would likely be fatal to the hostages and to others helping in their release. It is precisely because of this concern that knowledge of this operation within the administration was so closely held and shared on only a very strict need-to-know basis. Indeed, I was among those not kept advised of the Iranian initiative after rendering the advice that I mentioned in January of '86. Apparently, there was no continuing need for me to know of efforts undertaken to implement this program. and in that regard I had not been included as a necessary participant in 1985, when the concept of an Iranian strategic initiative had first been suggested and developed. And I, along with some other members of the National Security Council, had not been informed at any time in 1985 about any arms shipments that occurred during that year or about any related presidential findings prepared or signed prior to January 1986. I had no awareness of such matters until I learned of them for the first time in November 1986 and thereafter. As the testimony of others before these committees has indicated, there were only 2 occasions that I can recall in the summer of 1986 when Department of Justice matters prompted a conversation between me and Admiral Poindexter that related to the Iranian initiative. On both occasions, I acted in my capacity in those matters as the country's chief law enforcement officer. The first arose as the result of an inquiry from within the Department of Justice concerning a criminal investigation originating in New York relating to arms smuggling to Iran. The suspects in that investigation alleged that the United States government had authorized their arms sales. Criminal division attorneys had asked that I check to be sure that no such authorization existed. I therefore called Admiral Poindexter and received his assurance that the arms sales in question had not been authorized and were not connected with the Iranian initiative. A declaration was subsequently filed in court, I believe, that stated this fact. The second incident occurred around the end of October 1986. Admiral Poindexter telephoned me and inquired about a federal investigation which included an air carrier known as Southern Air Transport. He advised that the airline was involved in efforts concerning the Iranian initiative that were at a critical stage. He therefore asked whether it might be possible to delay a scheduled visit of investigators to Southern Air for around 10 days so as not to disrupt this activity relating to the Iranian initiative. I informed Admiral Poindexter that we obviously could not impede, weaken, or interfere with the investigation, but that I would check with FBI Director Webster to ascertain if it might be possible to delay certain non-urgent aspects of the inquiry. Through Associate Attorney General Trott, who handles the criminal matters within the department for me, I was informed by Director Webster on the 30th of October 1986 that the delay could properly take place without in any respect adversely affecting the investigation. I have since been advised by Director Webster that this is precisely what occurred, that the investigation of Southern Air Transport resumed on November the 26th, and that it was in no way prejudiced by that delay. In early November of 1986, events occurred which were of great consequence to the Iranian initiative. On or about the 4th of November, following publication of a story in a Middle Eastern journal, American newspapers began to print widely varying accounts of this matter. Therefore, on the 7th of November, I advised Charles Cooper, the Assistant Attorney General for the Office of Legal Counsel, which is the office that assists me in my responsibility as legal advisor to the President and the executive branch, including on matters relating to national security, that his efforts would probably be needed on the legal issues that might arise in regard to the Iranian initiative. The following Monday, which was the 10th of November, I attended a meeting with the President and other advisors at which the Iranian initiative was generally discussed. On the 13th of November, the President addressed the nation on the Iranian activities. 6 days later, on the 19th of November, he held a press conference on the subject. At Admiral Poindexter's invitation, I attended a meeting in his office the next afternoon, the 20th of November, with Director Casey, Assistant Attorney General Cooper, and for most of the time, National Security Council Staff Counsel Paul Thompson and Lieutenant Colonel North. There may have been others present from time to time. I was invited to that meeting as the President's legal advisor to review the legal aspects of the Iranian initiative prior to administration witnesses being called upon to give scheduled testimony and briefings before the Congress. I recall seeing for the first time at that meeting a draft chronology of events that from all appearances had been prepared earlier in the day by the National Security Council staff. In addition, drafts of proposed testimony were distributed, again, which I was seeing for the first time. Those documents were reviewed and discussed, and corrections and revisions were made at the suggestions of those who had knowledge of specific events. Mr. Chairman, questions have been raised during prior hearings of these committees here about my participation in this meeting and whether I so-called acquiesced in the statements included in the proposed testimony being prepared. The truth is, I did not at the time have knowledge sufficient to allow me to make any sort of judgment regarding the accuracy of the proposed testimony or the prepared chronology or the revisions or corrections that were being suggested. You will recall that the Iranian operation had been rigorously compartmentalized, and only those, as I stated earlier, with a need to know were brought into the planning and the implementation. Thus, while I was generally aware on the 20th of November, 1986, that there may have been arms transfers to Iran by Israel in 1985, I had no personal knowledge about such shipments, about our role, if any, in assisting with the transfers, or about the contemporaneous knowledge of other administration officials concerning the details of these shipments. It was after that meeting, late in the evening, when I first learned in a secure telephone conversation with Mr. Cooper, I happened to be at West Point, New York at the time, that there were apparent differences in the recollections of the Secretary of State, former National Security Assistant Robert McFarlane, and perhaps others. I was concerned that great care be taken to resolve these differences so that accurate testimony would be given at the congressional hearings and briefings that were scheduled for the next day. I believe that because the Iranian initiative had been such a highly sensitive matter, and because it had been so rigidly compartmentalized, no one seemed to have all the facts, and all seemed to me to be trying to piece together various parts of the story without full knowledge of the events. As a consequence, there appeared to be considerable confusion as to what occurred when, and the many conflicting and inconsistent news stories only seemed to exacerbate the situation. It was for this reason that I went to see the President the next day. I advised him of my concerns and recommended that he have someone undertake a fact-gathering review into the Iranian initiative to ascertain a fuller and more accurate picture of the events and the activities that had occurred. The President agreed totally with my assessment and directed me to commence an immediate review. I had indicated that I would be willing to do that if he so decided. He asked that I complete this task before the National Security Planning Group meeting, which was to be on this subject, and that had been scheduled for 2:00 p.m. on Monday, the 24th of November. It might be helpful if I spend just a few minutes on the activity that took place during that weekend. The essential point to keep in mind is that our purpose was not to conduct a criminal investigation. Indeed, on the 21st of November, there was no hint that criminal activity was in any way implicated in the Iranian arms transactions. Indeed, I later learned that the Criminal Division of the Department of Justice had separately conducted its own independent review of criminal statutes that might possibly be involved, and as reflected in a memorandum dated the 22nd of November 1986, found no basis to suspect that crimes had been committed. Early Friday afternoon, this is now the 21st of November, after my meeting with the President, I discussed the matter of the fact-gathering inquiry with FBI Director William Webster, who concurred that it would be inappropriate to utilize FBI investigators. Our purpose, plain and simple, was to find out what the facts really were and report to the President. I therefore put together a small team of lawyers who were knowledgeable about national security matters and proceeded to systematically talk with each of the persons having information about the Iranian initiative and to review the applicable documents. As Secretary Shultz said in his testimony last week, our efforts in the space of just over 3 days turned up the essential facts that are still the essential facts today. Obviously, much more information and many additional details have been uncovered by the various investigations, including those by these committees, and the months of effort that have taken place since that weekend. But the basic outline of facts that the President and I related to Congress and to the public on the 25th of November, 1986, remains intact today. From the afternoon of Friday, November 21st, through the evening of Monday, November 24th, a number of people were interviewed, documents were examined, and information was obtained from the relevant agencies that had participated in the Strategic Iran Initiative. Much of the information we obtained has previously been provided to these committees by the witnesses that have appeared before you and in the depositions and the documents which are part of your record. Therefore, I will not chronicle in detail the events of that weekend, but I will, of course, be happy to respond to any questions you may have about it. During our review, we discovered facts indicating that funds obtained from the arms transfers in Iran had been diverted to the democratic resistance forces in Nicaragua. I brought this information to the President, who determined that it should be reported promptly to the Congress and to the American people, and that immediate corrective action should be taken. Therefore, on Tuesday, the 25th of November, 1986, a briefing for congressional leaders was held at 11 o'clock, and a news conference was conducted at noon. Although our information was by no means complete at that time, and we recognized that much investigative activity would follow, the President requested that I disclose all that we had learned to date so that there would be no claim of withholding of information or charge of cover-up. Several actions were immediately commenced to pursue the necessary follow-up investigations and remedial actions. The President announced that he was convening a special review board to investigate and make recommendations to ensure that the mistakes made in implementing national security policy in this case would not occur again. We also took immediate action concerning the possible criminal law implications of the information which had been uncovered. I therefore met with Assistant Attorney General William Weld, who heads the Department's Criminal Division and headed it at that time, to discuss the initiation of an investigation by his attorneys and the FBI into the possible violation of criminal statutes. That process was well underway by the same evening. I also directed Deputy Attorney General Arnold Burns to contact the White House counsel to secure all files in the NSC offices. As these steps were being taken, it was clear to me that the initiation of an independent counsel investigation was probable. The activities of the Criminal Division included the initial inquiry to determine whether the legal and factual predicates required by the independent counsel statute were present. By the 2nd of December, I had concluded that seeking an independent counsel was appropriate and advised the President of this fact. On the 4th of December, the formal request for assignment of an independent counsel was presented to the Special Division of the Court of Appeals for the District of Columbia Circuit. That request was ultimately granted, and Lawrence Walsh, as you know, was appointed as independent counsel. Since then, I have continued, in accordance with the President's wishes and my own best judgment, to be fully supportive of and cooperative with all the official inquiries into this matter. Today is my 6th session of testimony on this matter. Others in the Department and elsewhere in the administration have also appeared multiple times, and there has been an unprecedented willing disclosure of perhaps millions of pages of stated goals of these hearings. The need for a constructive relationship between the executive and the legislative branches in the conduct of foreign policy. It is in the spirit of hoping to assist you in your examination of the facts and in contributing toward the cooperation between our respective branches of government that I am pleased to be here before you today, and I welcome any questions you, the members of the committees, and your counsel may have.
I thank you very much, Mr. Attorney General. Mr. Niels.
Thank you, Mr. Chairman. Good morning once again, Mr. Attorney General. In August and September of 1985, and then again in November of 1985, Israel made certain shipments of weapons to Iran. And I think you've already covered this, but I want to make it clear. Did you have any knowledge of either of those shipments at the time?
I have no recollection whatsoever of having any knowledge of those shipments at the time, Mr. Niels.
There was a finding drafted by the CIA and specifically its General Counsel, Mr. Sporkin, on the 25th of November, 1985, which was eventually signed, according to the testimony of Admiral Poindexter, on December the 5th, 1985. Were you consulted in any way in connection with that finding?
No, Counsel, I was not.
And did you have any knowledge of it at the time?
I had no knowledge of it at the time.
I take it then that your first knowledge of the so-called initiative involving arms sales to Iran came in January of 1986.
That is correct.
I think you've testified, or in your opening statement you've already said that you had at least 3 meetings, one of which I think you recall only through looking at records, which was the one on the 6th of January.
That is correct.
And one on the 7th of January.
That I recall very well.
And one on the 16th of January, and maybe one other.
That's correct.
I'm not going to ask you to go through these meetings again, since you've already described them in your opening statement, but I take it it's fair to say that the one on the 6th involved Oliver North.
Yes, it did.
And the one on the 7th included various members of the cabinet, Director Casey, Admiral Poindexter, Secretary Schultz and Weinberger, and the President.
Yes, sir, and also the Vice President, I believe, I don't know whether you mentioned Donald Reagan, the Chief of Staff of the White House, and it's possible there may have been one other person there from the NSC staff. I can't remember for sure.
And the one on the 16th included at least Admiral Poindexter, General Counsel Sporkin, Secretary Weinberger, and yourself.
Yes, and I believe Director Casey was there. As to Secretary Weinberger, I'm not sure that he was there for the entire meeting, but I believe he was there for at least part of the meeting. I don't have as good a recollection of his presence.
I take it that one of the issues on which you were consulted during these meetings was the policy question of whether it was wise to sell arms to Iran under the circumstances.
In the meeting on the 7th of January with the President, the issue of whether the Iranian initiative, and it was never confined to selling arms per se, it was a total initiative. It had several objectives which I related in my opening statement, but just to again refer to them. First, it was always in the light of this being a very dangerous area of the world. The presence of the Soviet Union and the menace to the region by the Soviet Union was one that was a part of the total backdrop of the discussion. The initiative had to do, first of all, with the objective of developing a channel of communication with elements in Iran. Iran has several factions in its government, and it was felt that one of the factions, or representatives of one of the factions, might be amenable to continuing communication so that we would be able to increase our influence over that government, either in the near future or in the distant future when there would be a change in that government. Secondly, an objective was to use contact with that element to try to end the Iran-Iraq war. A third objective was to, again, through that medium, through those forces, to try to decrease Iranian participation in or sponsorship of terrorism. And fourthly, to try to encourage that group to use their influence to assist in the obtaining of the release of hostages that were being held in the Middle East. The transfer of weapons was a part, as I mentioned in my opening statement, of reciprocal good faith on both sides. And the issue was discussed at great length. That was the primary discussion in the meeting on the 7th, of whether this should be done or not.
And I take it that, I think you've said it, you recognized it as a risky proposition, but on balance you thought it should go forward. I gather, or I guess I would like to ask you whether a factor in your thinking was the question of whether the venture was likely to succeed.
It was in part whether it was likely to succeed. There were risks involved in terms of the people who were involved in Iran. There was questions as to whether it would succeed. There were questions, frankly, about whether it was a good idea to include the transfer of arms as a part of the showing of good faith. All of these were aspects that were discussed at that meeting.
Did anyone at that meeting or any of the other meetings during January make reference to the fact that Benjamin Weir had been released simultaneous with an earlier transfer of weapons?
Counsel, I cannot recall whether that was mentioned or not at that meeting.
Did anyone make any reference to any of the prior history of this initiative at that meeting?
No, at that meeting, I do not remember any reference to the prior history of the initiative. I've thought afterwards that it's possible some people might have made allusions to it, but I would not have had the background to pick up the allusion if they had.
Did anyone, for example, make reference to the possibility that as a result of what had gone before, it would be dangerous to the hostages' lives to stop now?
No, I don't recall anything of that nature. Everything that I recall about that entire meeting was that the whole project was prospective in nature.
Did anyone make reference to the fact that the most recent transaction, the one which you now know occurred in November of '85, had caused the Iranians to be angry, that it had been botched, and that it was important to repair the situation?
No, sir, I don't recall any discussion such as that.
I take it that another issue on which your advice was sought was the propriety of not notifying Congress at the time.
There was a brief discussion of that. Actually, I think Director Casey raised that issue, said that he and his counsel felt it would be appropriate to delay the notification of Congress. There was discussion about notifying Congress as soon as possible, and I believe there was discussion at that session that we wouldn't even wait until the hostages were back in Wiesbaden. I think that was where they had planned to take them, but that as soon as they were on board the planes and under United States control, that there would be an immediate notification of Congress.
And I take it eventually you concurred in that procedure?
I said I thought that that was correct, but I wanted to check the law first, and which I did, and then gave my views in more detail, or at least my concurrence with the CIA view on the 16th of January.
Did anyone tell you during any of these meetings that the President had 1 month earlier signed a finding in connection with this initiative which called for postponed notification to Congress?
No, sir, I cannot recall any mention of that at all.
And that includes General Counsel Sporkin at your meeting on the 16th?
That's correct.
Made no reference whatever to the prior finding?
I do not recall any reference whatsoever to any prior finding that had been signed by the President.
What was I think you've already given the practical basis for your judgment that postponed notification was warranted. What was the legal basis for your judgment that it was permissible?
The legal basis was that Section 501B of the National Security Act of 1947 provides that the President, if there has not been prior notification under Section 501A, shall make timely notification of the Congress.
Were you aware at the time, either your initial conversation on the subject or after you had checked the statute, of views expressed in the legislative history by members of Congress, and most significantly the chairman of the Senate committee who's presiding today, Chairman Inouye, that the only circumstance in which prior notification could be foregone would be where the executive did not have time to notify Congress in advance?
I'm not sure that I was aware at that time. Since that time, I have looked into the legislative history, and I've seen references to a variety of views that were expressed when the amendments were passed in 1980, views of members of the Senate which also indicated that there were some severe limitations on what Congress could impose upon a president regarding regarding notification because of his constitutional responsibilities. There was a colloquy between Senator Javits and Senator Huddleston, particularly in this regard, and that there was also legislative history that the word timely was inserted because, and also words such as consistent with the President's constitutional responsibilities and duties and so on, so as not to create a confrontation over this particular act. There was also testimony, I believe, before the Senate in that regard by Admiral Stansfield Turner, who was at that time the Director of Central Intelligence, as to the lack of desirability, or indeed the danger of Congress requiring, under certain circumstances, notification immediately by the President. There was also, I believe, a considerable discussion of this at the time of the signing of the act that included this particular provision by President Carter, acknowledging the prerogatives of the President and reserving, in effect, the ability of the President to delay notification of the Congress. Indeed, I think there's been written material by Admiral Turner since that time noting that, in fact, there were such delays by President Carter during his administration.
Did you review any of this material at the time, prior to giving your opinion?
Now, at the time, I reviewed the statute and I believe the annotations.
Did you consult with anyone else in the Department of Justice on the question?
No, I didn't. I would have ordinarily, but this was such a closely held matter that it was my understanding that no one was to know outside of that very small group of people that was involved in advising the President on the 7th, and those people in the operating departments who were necessary to implement the initiative.
I take it then that there was no opinion done in writing on this question.
That is correct. Not at that time. There have been opinions since that time.
And I take it that would include any opinion that made no reference to the specific facts of this initiative, but addressed the question of what the timely notice requirement meant in the statute. At the time, there were no opinions on that.
There were none done at that time. As I say, there has been since.
You've testified, I think, to the length of the delay which you anticipated at the time you gave your opinion on the propriety of delaying. Can you tell us again just what your understanding was of the length of the delay?
My understanding was that this would be a near-term type of activity, that things were going to go forward virtually immediately and that it would be accomplished in 30 to 60 days. I'm not sure that anyone actually put that time frame on it in the discussion, but it was certainly implicit in what was said at that time. There was discussion about the weapons transfers taking place, the hostages coming out immediately, and it was in that kind of a time frame that it was discussed in general terms.
You may want to make reference to Exhibit 9, which is, you don't need to, but I'm going to make reference to it. It is a cover memorandum to the January 17th finding. And on page 2, at the bottom, it says, if all the hostages are not released after the first shipment of 1,000 weapons, further transfers would cease.
I do not believe that I ever saw this document at the time, but that certainly is consistent with what we were led to understand was a part of the discussion that I remember taking place on the 7th of January, and this was what led me to believe that this would be a very short-term operation.
Just to make it clear, either the weapons would be delivered and the hostages released, at which point notice would be given, or the weapons would be shipped and the hostages not released, in which case the whole thing would be terminated and notice could be given.
That's what this says, and that's what I remember being discussed on the 7th of January.
Now, as we all know, at this point, the weapons were shipped, no hostages were released. but the initiative was not terminated. Were you ever advised that there was a change in plan in terms of the length of delay?
No, sir, I was not. I found out about it, obviously, in November of 1986, that in fact is what had occurred.
At any of the meetings in January of 1986, did anyone point out the advantages of consultation notice to Congress?
I don't recall anyone pointing out the advantages of consultation with Congress or notification of Congress. It could possibly have been raised by someone on the 7th, but I certainly don't remember anything. I think I said in my opening statement that there was no one who was arguing for notification. I don't remember anyone.
No one, for example, argued either that it would be helpful to get input from congressional leaders or that it would be helpful if the project failed to have some congressional support behind you?
Not that I recall, Mr. Niels. Actually, the notification of Congress was a very brief part of the meeting on the 7th. The principal discussion at the meeting on the 7th of whether this should be done at all, and there was a rather heated discussion of that, in which I only had a very minor part. It was primarily conducted on the one side by Secretary Schultz and Secretary Weinberger, on the other side by Director Casey and Admiral Poindexter.
Was this discussed as a United States government proposal or an Israeli government proposal that the U.S. was agreeing to or participating in?
My best recollection was that they had talked about that Israel had made suggestions about this initiative, and indeed I believe that someone, a representative from Israel, had visited with Admiral Poindexter just a few days before.
I may say that, again, you may refer, if you wish, to Exhibits 7 and 9. You already have 9 in front of you, which is the cover memorandum to the January 17th finding.
Right, and I see there that it starts out by saying, and by the way, this is the memorandum from Admiral Poindexter to the President attaching the covert action finding regarding Iran, and it starts out by saying that Prime Minister Perez of Israel secretly dispatched his special advisor on terrorism with instructions to propose a plan by which Israel, with limited assistance from the United States, can create conditions to help bring about a more moderate government in Iran. So it does certainly verify that point.
And is that consistent with your recollection of how the project was briefed to you at the time?
Yes, sir, it is. And I'm looking now at Exhibit 7, which talks about covert action finding regarding Iran, which appears to be a similar document.
That document, I should say, is dated the 4th of January and is believed to relate to the finding which was signed on the 6th of January. The Exhibit number 7, which is the one dated January 4th, describes a proposal pursuant to which Israel would ship weapons from its stocks, which would later be replenished by the United States. The Exhibit number 9, which is the cover memo for the January 17th finding, describes instead a transaction pursuant to which the United States would ship its weapons directly to Iran. And it places the change on legal grounds. And I might read it. It's at the bottom of page 1 of Exhibit 9. And it says, "We have researched the legal problems of Israel selling U.S. manufactured arms to Iran. Because of the requirement in U.S. law for recipients of U.S. arms to notify the U.S. government of transfers to third countries, I do not recommend that you agree with the specific details of the Israeli plan. However, there is another possibility," and it makes reference to the opinion of Attorney General Smith that you referred to earlier, and states that the objectives of the Israeli plan could be met if the CIA, using an authorized agent as necessary, purchased arms from the Department of Defense under the Economy Act and then transferred them to Iran directly after receiving appropriate payment from Iran. And I guess my question to you is, were you consulted on the legal issues raised by Israel selling from its stocks, followed by replenishment, as compared with direct sales from the United States to Iran?
I believe there was a discussion of that in which I participated at the time that we were looking over the finding, possibly on the 16th of January. I do remember that at the meeting on the 7th of January, my best recollection is that Bill Casey said to me, "You remember Bill Smith's memorandum and I don't know whether he gave the exact date, which was in 1981 or some years earlier, authorizing CIA to transfer weapons under the National Security Act." And I did remember that because I had been present during a rather lengthy discussion of that at the National Security Council, and I indicated that I did. This was really the basis for the discussion. I believe Secretary Weinberger at the meeting on the 7th said that he wanted to check that out with his general counsel, that this could be done through the National Security Act rather than the Arms Export Control Act. My recollection is that either while I was there or separately, he had provided the information to Admiral Poindexter that his general counsel was satisfied that the National Security Act could be used, and there was at least a brief discussion in my presence in Admiral Poindexter's office on some occasion, I think it was the 16th, in which a variety of different modes of transfer were discussed. One was the Israeli proposal of the Israelis transferring their weapons and our government replenishing their supply. A second method was to go through an international arms dealer in which the Israelis would not be involved directly, and a third option was to have the CIA transfer the weapons directly to Iran or through Israel, but where CIA would be the principal entity doing it, as is set forth here in Exhibit number 9. I believe that the recommendation of the CIA General Counsel was that be the method that be used. Certainly I agreed based upon Mr. Smith's memorandum, which incorporated an original opinion that had been established by the State Department and with which the Department of Justice concurred in 1981 in another matter.
I think I understand, but I want to make certain. The committee has heard testimony from various sources, General Counsel Sporkin, some people from the Defense Department, and other testimony that there would be problems raised, legal problems raised, if the Israelis transferred weapons that they had earlier purchased under the Arms Export Control Act, and that it was a cleaner and more appropriately legal way to do it, to simply transfer directly from the United States to Iran pursuant to an intelligence finding.
Yes.
Did you concur with that judgment at the time?
Right. Let me just amend by saying pursuant to an intelligence finding and through the provisions of the National Security Act, and I did concur with that, yes.
Now, I take it from your opening statement that you were pretty much not in the loop, so to speak, from the time this finding was signed on the 17th of January until the publicity that arose in the November 1986 period.
That is correct.
I think you made reference to a couple of brief consultations on tangential matters, but I take it you were not advised of particular shipments, for example.
That is correct.
Now, I take it then during the week of the 3rd of November 1986, some newspaper reports appeared making reference to this initiative.
That's correct.
And I think that the record reflects that initially the President indicated publicly that these were without foundation, or words to that effect, but the articles continued, and there was a meeting of various members of the National Security Council on the 10th of November 1986. Do you have a recollection of that meeting?
I don't recall statements by the President that you've characterized, but I do recall the meeting on the 10th of November, yes.
And was one of the topics of that meeting the question of what the press ought to be told about the initiative?
Let me first state, Mr. Niels, that the meeting on the 10th of November, I believe you characterized it as a National Security Council meeting. Did you?
I think I said various members of the
Okay.
National Security
Because
Council were present, but I will ask you that question.
Yeah.
Was it a National Security Council meeting?
It was not, and that's the point I wanted to make. It was a meeting in which a few members of the National Security Council were gathered in the President's office, in the Oval Office, I believe, rather than where the National Security Council or National Security Planning Group would normally meet, which is either the Cabinet Room or the Situation Room. At that meeting, and if I may, I will refer, I believe you have an exhibit that has some notes of mine on the 10th of November. If I may look at the...
And I think you're referring to exhibit number 17.
Okay, you're...
And we would appreciate it if you would, at least for the time being, use that solely for purposes of recollection refreshing.
Yes. I do have, I'm now referring to exhibit 17, which characterized, interestingly enough, I've characterized it as a national security meeting, not a National Security Council meeting. I think that may have a significance that I mentioned to you. In the Oval Office on the 10th of November at 11:30. I'm looking now at my notes to refresh my recollection. I see a note that I took that says, Washington, D.C., too much talk, which may have to do with press accounts. And I see here my notes that says, lives of those with whom we deal, for example, in Iran, could be jeopardized, which I'm sure was at least possibly in reference to how this should be handled with the news media. I don't have any other notes, but I am sure that at least a part of that meeting was involved with how this should be handled with the press.
What was the President's position on that subject at that meeting?
I think his position, as best I can recall, was that we should be very careful in statements to the press for a variety of reasons. He was concerned about the hostages who are still in Lebanon. He was concerned about the elements in Iran, because at that time I believe there was some discussion that at least the communication with those elements could perhaps continue. I have a note here that says that debriefing of Jacobson may lead to new opportunity, which would lead me to believe that we felt there was still a possibility of getting hostages out. And I also have a note on my notation here on the second page of my notes that says, North, 2 more hostages by this weekend, which leads me to believe that there was still hope that we would get hostages out even in the course of this revelation. So I believe the principal concern that the President had in regard to the way in which this is treated by the news media was do nothing that would endanger either the hostages or the people in Iran.
There's another set of notes that relates to this meeting, which is Exhibit 19. They are Mr. Keel's notes. On page 7 of them, the President it is attributed to the President. We don't talk toes, don't talk specifics. Is that consistent with your recollection of the position that the President took at the meeting?
Well, I'll assume it's here. I can't find it, but matter of fact, I can hardly read it.
It's difficult to read.
But in any event, I don't have any recollection one way or the other whether he said that specifically. I do know that the more details that were given, such as toes, the more danger there would have been to the people in Iran and presumably to the hostages as well, so that would not be inconsistent with what I recall as the general tenor of the meeting.
Do you recall any other contrary views being expressed?
No, I do not. As a matter of fact, I think that was the general sentiment of most of the people there.
either at the meeting or following the meeting, I guess I want to ask you, following the meeting, did you ask anyone in the Department of Justice to commence legal research into potential legal issues that might arise as a result of the publicity?
Yes, I had already given a warning order, I believe sometime the previous week prior to on or about the 6th or 7th of November. I think Admiral Poindexter had talked to me about possibly needing some legal advice or at least some help on legal issues. It was anticipated at that time that there would probably be testimony and questions raised in Congress, and he alerted me that probably we would need some legal assistance. And so on the 7th of November, 1986, at a management planning conference that we were having, that was a Saturday, I believe, or Friday actually, I asked Mr. Cooper, just very briefly, I alerted him to be prepared that he, and I suggested that he have one other trusted person in his section be prepared to do some legal research on this, and I may have even mentioned at that time that he might be hearing from Commander Thompson, who was the assistant to Admiral Poindexter, and I believe served generally as the legal counsel for the National Security Council staff.
I take it at that time you were aware that there had been a presidential finding signed on the 17th of January.
I'm not sure that I knew it had been signed. I knew it had been prepared because I had been part of the preparation on the 16th, and so I assumed that it had been signed, yes.
And I take it, based on your familiarity with the prior opinion of Attorney General Smith, and from having read the statute, you felt comfortable that the transactions that had been done pursuant to that finding were appropriate?
Yes, sir.
Were you at that point in time aware that there had been these earlier Israeli transactions which had occurred prior to the time of any finding?
I'm not sure that I was aware on the 10th. I'd have to look back at my notes, which are Exhibit 17. And I don't remember whether we were told on that day as to what the time sequence was, or whether this was in 1985 or 1986, or whether we were told at all. I do know that my notes show that Admiral Poindexter talked about our well, the meeting started with the President saying that there was no bargaining or trading for hostages, and he said we would not trade anything in return for hostages. Admiral Poindexter said it had to do with our long-term strategy in regard to Iran, listed the objectives which I've already referred to, and then talked about the 17th of January 1986 finding. So the finding was actually referred to in the meeting on the 10th. And then talked about Israelis, talked about a warehouse in Portugal, talked about a McFarland trip to Tehran in May of '86, and talked about the arms transactions, including the numbers of arms that had been shipped and the different shipments. It is interesting to note that at that time he talked about 1,000 TOW missiles. Later on, in subsequent meetings, it was learned that that number was too low, that it was erroneous. It was twice that many. It was over 2,000 TOW missiles, and so on. And then, so I don't know here whether, in fact, anything was mentioned specifically about 1985 in that meeting. I did ultimately learn that there were transactions that took place between the Israelis and Iran in 1985. But whether I knew them on the 10th, I'm not sure.
While we're on that meeting at the 10th, you might want to refer to Exhibit number 19, second page. Those are Mr. Keel's notes. You have those in front of you?
Yes.
Up near the top of the page, there's a little 1 with a circle around it.
Mm-hmm.
And opposite that, it says, first 500 TOWs went, and it looks like without permission.
Mm-hmm.
We found out, eventually reimburse Israel.
Mm-hmm.
And then it says, Ed, we didn't sell, and then in parentheses, Israel sold. And then it looks like was multi-phased transaction.
Right.
Now, first of all, do you have any recollection of that interchange?
No, I don't have any recollection of it. I don't know whether that was a question I asked or a statement I made.
But it would appear from the notes that the subject of the earlier Israeli transaction came up, and you either knew something about it or are asking a question about it.
Well, I don't know that I knew anything about it. I do know that even whether this was an earlier transaction or a later transaction, because it was originally described in our meeting on the 7th of January that we would have this multi-phase transaction was the suggestion of the Israelis. That was what had been explained to us initially, even for the 1986 transactions. And I'm not sure that I knew which of the three alternatives had ultimately been adopted by the President, because I had never seen that memorandum that Admiral Poindexter sent to the President, which you described earlier as, I believe it's Exhibit
9.
Exhibit 9, which is the memorandum dated the 17th of January. So I may have been had in mind when I asked that question the original plan of the Israelis, because it said in these notes here, it says at the top of the page, Bud went in May 1986, the only trip, and then after that it says sold 1,000 tows and sold 240 types of hawks. So I don't know whether we were told actually that any of this had taken place in 1985 at that point in the meeting.
In any event, I take it at some time within a matter of days after the 10th of November, you became aware that there had been these pre-finding shipments by the Israelis.
Yes, sir. I believe Mr. Cooper actually told me that he had learned that from Commander Thompson. I may have learned it from other sources as well.
Did you have a meeting with Mr. Ledeen on the 14th of November?
Yes, I did. I believe so. And I believe we have an exhibit that relates to my notes or my calendar that indicates that. Could you?
That should be exhibit number 25.
All right. Yes, this is from my daily kind of a spiral notebook that I keep, dated the 14th of November 1986, and it shows that Michael Ledeen at 2:05 p.m. met with me in my office.
Now, Mr. Ledeen was, based on the information that is available to the committee, was involved in the transactions in 1985 and then stopped being involved sometime prior to the January 17th finding. Do you recall what you were discussing with Mr. Ledeen and what the reason for the meeting was?
Yes, Mr. Ledeen asked to see me because he said he wanted to talk to me about some matters relating to terrorism. And at the start of the meeting, he said, I want to talk to you also. He said, I want to mention about Iran. He said, my notes reflect here, he said, we can still work with the original Iranian group with which he, Mike Ledeen, initiated the original contacts. And he mentioned Ghorbanifar and others. Then I put a note at the side, says, Mike claims to have worked with McFarlane in 1985. And he had referred to something called Channel 1. Channel 1 had been referred to in the meeting, I believe on the 10th, that there had been two channels that had been worked, although I did not know the time sequence, I don't believe, with each of them. Then he got on to the business that he'd actually come to see me about. There were two items, basically. One was he said that, that there was a lot of information in the hands of journalists that was not getting to the FBI about terrorism, and he felt that the FBI should be more aggressive in talking to journalists, particularly who had been overseas, who would have information and knowledge. I don't remember this without having refreshed my recollection from the notes that are deleted from this memo prior to this meeting, I might add. And the other thing that he talked to me about was that he was available to help the administration anyway in matters relating to terrorism. I might say parenthetically that as to this item on Iran, I did not pursue that with him. I didn't know how much he knew. I didn't know how much he was authorized to know. I didn't know what his connection was, so I just dropped the subject, and we went on to talk about what he had come to see me, which was the terrorism generally.
Do you recall if he made reference to arms transfers in 1985?
I don't recall that he did, and I don't have any notes that say that he did, other than that he claims to have worked with McFarlane in 1985, presumably in regard to some relationship with the Israelis.
I take it would be fair to say that at whatever time you learned from Mr. Cooper or from whatever other source about these pre-finding transfers, that they raised a different and more difficult legal issue than the transfers occurring pursuant to the January 17th finding.
Yes, they did, and although Mr. Cooper had only briefly mentioned that to me, I didn't have a very great deal of knowledge about it, didn't know much about it at the time.
The President had a press conference on the 19th of November.
Yes.
Did you have any part in briefing him for that press conference?
No, I don't believe that I know that I didn't have any part in the briefing. I don't know whether any information was asked of us for the briefing. It may have been from someone in the Justice Department, but I had no personal participation in the briefing.
Okay, I want to ask you about that second part of your answer, and you might want to turn to Exhibits 30 and 31.
Right. I see an exhibit marked Exhibit 30, and I don't see the date, but it may the date can't be made out, but I think it may be the 19th or the 18th.
I believe it's the 19th.
19th of
looks
November.
like the 19th of November, stamped
Right.
in the upper left-hand corner.
It would show that I received a phone call from Peter Wallison, who was then the White House counsel, at 9:15 in the morning, and that one of the topics we talked about, the second topic, according to my notes, was a briefing of the President on the legal aspects of the Iran arms situation, and I presume that he did that.
Was he seeking some input from you on this subject?
No, I don't know I can't recall what the conversation was. By looking at exhibit number 31, I see that at our staff meeting on the 19th of November, a matter came up regarding the briefing of the President for the news conference on justice-related issues, so it's entirely possible I was calling him to say that our people were available to provide any information he might need for the briefing of the President. He would have been participating in the briefing, and I may have wanted to let him know that our people were available on the legal aspects. He may have asked me about it. I can't tell from my notes.
So you know the issue was raised with someone at the White House in connection with the press conference, and you don't recall exactly how?
Either raised with them by me, or he raised that issue with me, one of the two.
Did you listen to the press conference?
Yes, I was working late that night, and so I listened to a part of it in the car going home. I think it was at 8:30 or 9 o'clock, whatever time it was. I listened to a part of it in the car. I missed a part of it going from the car to the house, and then picked it up where my wife was watching it on television.
Did you hear anything that caught your attention or needed further attention?
Yes, I had heard or seen, one of the two, that the President had, I believe, mentioned that there had been no third countries involved, or words to that effect.
And did you do something as a consequence?
Yeah. Actually, my feeling at the end of the news conference was that I felt the President had not been properly briefed based upon all the information, even that was discussed at our prior meeting on the 10th, because the President is very good with facts and with details if he has received the proper information. And so I was concerned that the answers he had given on the 19th were not consistent with him having been thoroughly briefed for that news conference, including particularly this matter of no third country being involved.
Maybe we should just turn to it. It's exhibit number 32. And I think the portion that you have reference to is at page 1586. I take it there on the left-hand column, there's a question, Mr. President, I don't think it's still clear just what Israel's role was in this. The questions that have been asked about a condoned shipment. We do understand that the Israelis sent a shipment in 1985, and there were also reports that it was the Israelis that contacted your administration and suggested that you make contact with Iran. Could you explain what the Israeli role was here? Mm-hmm. And then his response is no, because we, as I say, have nothing to do with other countries or their shipment of arms or doing what they're doing. And the answer continues.
Right.
I take it that's one of the answers that you had in mind when you were listening to the broadcast.
That was one of them. I also, looking up higher in that page, I see questions about 1,000 anti-tank missiles and saying it's a shoulder-carried weapon. I wasn't that acquainted with TOWs at that time, but I had questions in my mind whether in fact it was a shoulder carried weapon. And also the other parts happen to be spare parts for an anti-aircraft Hawk battery. And as I say, all of those weapons could be very easily carried in one mission. There were a lot of questions there that had not been discussed at the meeting on, or there are a lot of issues that had not been discussed at the meeting on Monday, and I had some questions whether that had been properly briefed to the President as well.
I think then on the next page, 1587, there's another question and answer on the Israeli subject. At the bottom of the left-hand margin, left-hand column, there's a question, Mr. President, going back over your answers tonight about the arms shipments and the numbers of them, are you telling us tonight that the only shipments with which we were involved were the one or two that followed your January 17th finding, and that whatever your aides have said on background or on the record, there were no other shipments with which the U.S. condoned? And the answer is, that's right. I'm saying nothing but the missiles that we sold, and then the answer continues.
Right.
I take it those are the answers that, that prompted some action on your part, and if so, what action did you take?
I called Admiral Poindexter. It was primarily the reference to the third country, but this also was a question. And I was concerned about all of the answers, that they didn't seem to be the usual crisp, clear way that the President has when he's in possession of all the facts. And so I called Admiral Poindexter that night, immediately following, or within a few minutes following the television program, and asked him what had gone on, that the news conference had not gone well, and I didn't think the President had been properly briefed, or words to that effect. Admiral Poindexter said that the White House was issuing a clarification or a correction within a few minutes on the third country aspect. And I believe it was in that conversation he told me that the next day they were going to go over the testimony that was going to be presented to Congress on Friday about these matters, and asked me if I would attend a meeting in his office. I was supposed to be away that day. I was supposed to be at West Point the following day for an all-day trip, and so I told him I would delay my trip long enough to attend the meeting in his office in the afternoon.
The record should reflect there was a correction issued on the third country issue, and then moving to the subject that you just raised, I take it you did attend a meeting the following afternoon in Admiral Poindexter's office on the subject of the upcoming congressional briefings and testimony.
Yes, as I mentioned in my opening statement.
And I think you said that Director Casey was there, and he was scheduled to testify the following day, and Admiral Poindexter was there, and he was scheduled to give briefings the following day.
That's correct.
And you were there, and Mr. Cooper?
I was there, Mr. Cooper. I believe Commander Thompson was there for some or all of the meeting. I believe that Lieutenant Colonel North was there for at least part of the meeting, if not most of the meeting, and there may have been others present as well from time to time.
What was the purpose for your being there?
I think that it was the same purpose that Admiral Poindexter had talked to me earlier, that there would undoubtedly be some legal issues coming up, and I felt it was important that these legal issues be accurately stated, and therefore I delayed my meeting. I think I may have known about this meeting in advance and had planned to have Mr. Cooper attend. I'm not sure. But in any event, I planned to attend myself after talking with Admiral Poindexter on the evening of the 19th.
And and I take it again, you were there because of the possibility that some legal issues would arise.
That's right.
Now, of course, you were actually able to catch a factual error in the President's statement of the night before, based on your having been involved from the beginning in the fact that this was an Israeli proposal and that they were, in fact, involved.
Yes.
But your presence on the afternoon of November 20th was not, I take it, to give factual input, but rather legal.
Well, it was to certainly to give whatever legal input was necessary and to help in any way that I could.
Did the subject of the Israeli pre-finding shipments come up again at that meeting?
Well, yes, at that meeting as I mentioned earlier, I already had some knowledge from Mr. Cooper, very brief knowledge, that there had been shipments in 1985 prior to the 17th of January 86 finding. In that meeting, it did come up, and particularly, I think there was a discussion of some shipments, of a shipment of Hawk missiles in November of 1985. I remember that there was general discussion. For the first time, I saw also a chronology of the different shipments that had occurred, which the NSC had prepared. It was a two-page kind of calendar of events that had taken place, and I saw that for the first time. I remember was quite interested in that because that laid out for me in some detail the different shipments that had taken place, the hostages that had been released, and so on, in both 1985 and 1986. I also saw, at least briefly, a chronology, which was a more detailed narrative, which had been prepared by the NSC staff, I believe earlier that day on the 20th, and then saw testimony. And there was testimony that had been prepared for Director Casey, and there was also a memorandum relating to specifically the Hawk shipments in 1985, in November of 1985.
And the memorandum, could that also be termed an insert?
I think it was designed to be an insert, yes. It was in memorandum form. It said some subject, well, I imagine you have that as an exhibit also.
Yes, we do. It's Exhibit 33.
Okay. Exhibit 33, yes, this is what I'm referring to. It said subject CIA airline involvement, and that was, as I understood it, intended to be an insert in Mr. Casey's testimony, and this was discussed, and that's what I was referring to when I talked about the November 1985 Hawk shipments.
What do you recall about the discussion on the subject of this November 1985 Hawk shipment?
There seemed to be an awful lot of confusion about who had done what and how much people knew at the time. And I believe that Colonel North appeared to be the most knowledgeable person about what had taken place. I believe Mr. Casey, if I remember correctly, had actually been out of the country when this took place and didn't have much personal knowledge of it. There may have been someone else there from the CIA. I have a vague recollection that George Cave might have been there, but I'm not positive, or John McMahon or someone like that. In any event, there were corrections that were made in the insert that were suggested by different people there, such as, among others, I believe, Colonel North. Because I notice in my handwriting here that I've put in things that were suggested to be changed, and I have looked at another exhibit which is similar, and which I see here is exhibit number 34, where someone else whose handwriting I don't recognize was apparently doing the same thing.
Okay, just so the record is clear, with respect to Exhibit 33, that document contains your own handwritten interlineations, I take it?
Yes.
And particularly on the third from the bottom paragraph, there's in the middle of that paragraph, there's a statement, no one in the USG found out that our airline had hauled Hawk missiles into Iran until mid-January when we were told by the Iranians. I take it that's your handwriting that put in the words no one in the USG found.
Well, that's my handwriting, but someone else was the one who suggested that correction, and that's why I say apparently someone else was taking the same notes because Exhibit 34 has similar interlineations.
I think there's testimony on the record that the similar interlineations on Exhibit 34 are those of Colonel North.
I see.
Now, in some of the documents notes we've gone over today, and in some others that we have not, there were statements made during this time frame that the United States government didn't find out about the August and September tow shipments to Iran by Israel until after they had happened. Now, I take it with respect to this Hawk shipment, as you learned at this meeting, it was not possible to take that position because the CIA airline had actually been used to carry them.
That was not my understanding at the meeting. I believe at the meeting we were told that a CIA proprietary had been suggested to the Israelis or that the name of a CIA proprietary, but that airline had acted as a normal carrier and not as a CIA expedition. And there was some discussion back and forth on that at the meeting.
But in any event, there had been United States government participation in arranging the actual movement of the goods, whatever goods they were.
Well, what we were told at that meeting, and I had no knowledge personally as to whether this was correct or not, was that the only involvement well, first of all, we were told at the meeting that these were, to the best of the knowledge of people in the United States government, these were oil drilling parts. And we were also told that the only involvement of the United States government was to suggest an airline, which happened to be a CIA proprietary, and that the suggestion to the airline, and that the CIA would notify the airline that they should take this shipment.
Just so the record is clear, you said you were told at the meeting that the U.S. government believed they were oil drilling, had been told they were oil drilling parts.
This is my understanding, and that's my recollection of what we were told at the meeting, that was true.
Again, just so the record is clear, the understanding at the meeting, I take it, was that in fact what was shipped was Hawk missiles,
yes,
but that at the time of the shipment, the U.S. government was told they were oil drilling
Yes, sir, that's
parts.
correct. That's correct.
But there was at least some involvement of the United States government in actually moving whatever it was that we were told was being moved at the time.
Well, the involvement we were told about was the recommending of an airline to carry them, yes.
And who was it at that meeting that proposed this insert with this interlineation, namely that no one in the U.S. government found out that our airline had hauled Hawk missiles into Iran until mid-January?
I don't know for sure. I can't remember who. I think most of the suggestions, however, were coming from Lieutenant Colonel North.
Did anyone dissent from this, anyone at that meeting dissent from this statement in Exhibit 33?
I don't remember anyone dissenting, and I doubt if I would have written it in unless there was general agreement that that's what should have been put in there, that was what was agreed upon to be put in there.
Did Admiral Poindexter dissent?
Not to my recollection, but I can't be absolute. I'm sure that he did not, because I don't think he said much of anything during that meeting.
Did he dissent later on? Did he call you on the phone?
Not that I no, he did not.
I take it from your testimony that you were not aware at the time that this statement was contrary to fact.
I had no knowledge whatsoever about the truth or falsity of any of the material there. This was all new to me.
Did this question, namely whether the CIA or the U.S. government had acted with knowledge that there were Hawk missiles on the proprietary, relate to any of the legal issues that were on the table at the time?
I don't think we discussed this in regard to the legal issues at the time. I don't remember it, this coming up as a specific legal issue, although it may have. It obviously had a legal ramification as an after-the-fact consideration in November of 1986. But I don't remember much discussion of the legal aspects of it. It's entirely possible it did.
I take it when you left the meeting, this formulation in Exhibit 33 had been, as far as you were concerned, agreed to.
I believe that's correct.
And that's what, at the time you left the meeting, that's what Director Casey would tell the committees the following day, and that's what Admiral Poindexter would tell the committees the following day.
That's what I recall, yes.
Now, did you receive a call? I take it then you left the meeting and went to West Point.
Right. I flew to West Point, and where I was giving a talk at a banquet that night.
Prior to the time that you actually got on the airplane for West Point, did you receive any telephone calls on this subject, namely the Hawk missile in 1985 subject?
Yeah, I do not recall receiving a telephone call specifically, but I've been told that I did, and I believe it to be correct that I did receive a call and my understanding is it was from my deputy, Arnold Burns.
And do you recall what he told you in this conversation?
No, I don't recall it, and he doesn't recall what he told me, but as best as I can piece together from what others have said, he told me that there was some concerns about the statement that the testimony that Director Casey was going to give and that those concerns came from the State Department. And I have a very vague recollection. My best guess, I guess you'd have to say, based upon what Mr. Burns and I have talked about, is that I said something to the effect that we've just been working on getting that statement corrected, or something to that effect. In any event, something that, in effect, completed the conversation, but I can't recall specifically what I said.
I think you're making references to materials that have been made public, and they are to the effect that Judge Sofair had a copy of the same testimony that you had reviewed that afternoon, and had raised objections to the statement that there had been no knowledge in the United States government that Hawk missiles were being shipped, and made a call to your deputy and received a call back from your deputy that he discussed it with you, and that you were aware of the problem and knew facts that essentially made it okay.
Well, I'm not sure that it was his, I don't know what his objection was, and it was that he felt that there was something wrong with the testimony that Director Casey was going to give. And I said to Mr. Burns, as near as I can piece together, that we had just been correcting the testimony, so I assumed whatever problems he had would have been taken care of in the corrections that we made. Because to our knowledge, the one person who was most knowledgeable about this whole thing was Colonel North, and he had been there making the corrections.
Did you, let me withdraw that. Are you saying that Mr. Burns did not tell you what the problem was so far as the State Department was concerned, or that you've forgotten what he told you?
I can't tell you for sure. I don't recall the details of the conversation, but I'm almost positive he did not go into the details of the specifics of what the State Department concerns were, because that would have raised a lot of questions in my mind, and what he told me did not. And I think the reason he didn't is we were on a non-secure phone. I believe we were probably on a phone that was in my car as I was racing to Andrews Air Force Base.
Did he give you the impression that there was a sense of alarm at the State Department, or was it a...
Not that I recall, that it was that they had some of the same questions about the statement that we had just been correcting over in Admiral Poindexter's office.
I take it then you went to West Point, and at some point that evening you received a telephone call from Mr. Cooper.
Yes, sir. After several attempts to get the secure phone working, I think finally around 10:30 in the evening or so, I received a call from Mr. Cooper, which put quite a different picture before me, and that was that there was some severe concerns in the State Department that there was quite a good deal more knowledge within the United States government about the fact of Hawks being shipped in November of 1985 that was known then than anything we had been led to believe earlier that afternoon.
Was he specific?
Yes, since we're on a secure phone, he could be specific, and he indicated that Mr. Schultz had knowledge in November of 1985 and had been told, I believe, by Mr. McFarland that the shipment of the Israelis that was going to Iran did contain Hawk missiles.
Did he mention any documentary support for Secretary Schultz's recollection?
I think that he did mention that notes had been taken at the time, or that Secretary Schultz had notes about Hawk missiles being shipped.
And what did Mr. Cooper suggest that you do?
Well, he was concerned about this and said we couldn't let Director Casey go and testify the next day with erroneous information. And I said I absolutely agreed, and asked him to get in touch with CIA General Counsel I think his name was Dave Doherty at the time, that evening, and to go out, if necessary, to CIA in the morning before Director Casey left for his testimony, and make sure that if there was a difference of recollection on these matters, to be sure that either it was resolved, or if it wasn't resolved, to be sure that Director Casey did not put anything in his statement which might be inaccurate.
Now, I take it that from your opening statement and other information that you returned to Washington.
Yes, I was supposed to go from West Point to Harvard and participate in a seminar there. I decided that I better return because at that point my view was that we had so many different people involved in this and each had a little piece of the information that there was obvious confusion and that we better get a coherent account of what in fact had occurred.
Mr. Niels, is this a good place to take a recess?
This will be just fine, Mr. Chairman.
The hearing will stand in recess for 10 minutes.